Well, welcome everyone to the...
Hold, sorry. Okay.
Okay, with our technical people?
Yes, okay to proceed. Yeah.
Right, well, welcome everyone to the Hawkesbury Local Planning Panel meeting for the 21st of July, 2022. Before I start, I'd like to acknowledge the traditional custodians of the land, the Darug people, their elders past, present and emerging. The panel's been appointed by the Minister for Planning and Public Spaces and the Council to determine certain categories of development applications and also to provide certain advice as provided by the Environmental Planning and Assessment Act. And my name's Louise Byrne, and I'm the chairperson for today's panel. The other panel members with me today are John Brunton, Ian Hunt, and Paul Rogers. Just a couple of housekeeping matters. As a courtesy to others, please keep your microphones on mute at all times unless I call on you to speak. As you're aware, the meeting's being audio-visually recorded, and the audio recording will be via podcast to the Council's website. Any part of this meeting that's in closed session will not be recorded. The terms of the Privacy and Personal Information Protection Act, personal information provided at the meeting will be recorded. The provision of any information that is recorded is voluntary. Any person who does not wish to be recorded should not address the panel. Just by way of courtesy and behaviour in the meeting, it's expected that any person who's addressing the panel will not make any insults, allegations, or personal reflections against any person present or not at this meeting. And this request relates to both your address to the meeting and any answers given in response to questions from the panel. Under the panel's code of conduct, panel members are required to disclose any pecuniary or non-pecuniary interest in relation to matters on today's agenda. And I'll just orally record that I declare I have no conflicts of interest in relation to today's agenda and have also signed a declaration to that effect. Mr. John Brunton, can you respond?
I have no conflicts of interest and I've signed my declaration form.
Mr. Ian Hunt?
I have no conflicts of interest and have signed a declaration report.
And Mr. Paul Rogers?
Yes, I have signed the relevant declarations of interest and have no interest, conflict or otherwise in any matter before the panel today. Thank you.
Now, thank you, gentlemen. The panel will deal with items in the agenda order, and you all will have the papers for today's meeting. If you're registered to speak, you'll be permitted, if you've registered to speak, you're permitted to address the panel. The making of submissions are to be given in 3 minutes, if that's possible. We may permit some extension of that time in each individual case, but the 3 minutes will be timed. Now, at the end of your submission, please remain in the meeting to permit the panel to ask questions. For each item on the agenda, once all submitters have addressed the panel may adjourn into closed session to deliberate. This may take some time. Generally, the panel will resume the meeting to announce its decision in public, and the determinations of the panel will be confirmed in the official minutes, which will be available on the Council's website, usually by next Thursday. Now, today's agenda has 2 items on it. One of them is a matter of advice on a heritage listing, which is to be done in closed session. It's not a matter that's in a public forum. And that's the second item. So the other item, the first item, is a development application, DA 196/20 for lot 3 DP 270515 88B Bulgamata Road, Barrambing. Now, Mr. Andrew Johnson was the assessing officer for this DA, and I'll ask him to give a summary of that matter and the recommendation by himself. And then we have 2 registered speakers, Mr. Lionel Bucket and Mr. Roderick Story, solicitor. Mr. Bucket, I believe, is the applicant or owner of the land. And I note that Mr. Bucket has also sent to council a written submission, and we've agreed that that could go before the council and before the panel, and all of the panel members have a copy of that written submission. So I'd just ask Mr. Johnson if he can now explain this item, the first item, which is the Barrambing DA that's before the panel today. Mr. Johnson.
Thanks, Madam Chair. This particular application and this matter is being...
Can I just interrupt and ask you to come closer to the microphone, please?
Yeah, so hopefully this is a bit better. This matter is being reported to the local planning panel based on a previous resolution of the panel on the 21st of April. This application, DA 0196/20, was for the formalisation of 2 structures as tourist facilities. It was reliant on existing use rights. Having considered previous reports on this matter, the panel elected to defer the determination of the application for 3 months to allow the applicant and owner to submit a separate development application for the consideration of the structures on site as eco-tourist facilities. At the time of lodgement of the original DA 196/20, eco-tourist facilities were prohibited. Since that time, the Hawkesbury Local Environmental Plan has been amended to allow eco-tourist facilities. So within the last 3 months, the applicant and owner have lodged a new development application that's identified as DA 0200/22. That's for the use of 5 structures in association with an eco-tourist facility use. That particular application is under assessment. It has been referred to, internal and external referrals have been undertaken, and it's currently with the Rural Fire Service for comment. It's on notification until I think the 3rd of August. So that new application has been is under assessment, and I guess the resolution, the previous panel resolution, has been satisfied in that regard. The current application, DA 196/20, council has received legal advice in relation to existing use rights as a tourist facility. Based on that legal advice and the unlawful commencement of the use, the application is recommended for refusal.
Okay. Now, did the panel members just want Mr. Johnson to clarify anything that he has just said that will assist? No? All right, well then I'll ask Mr. Bucket, do you want to go first? You need to unmute your
Hello.
microphone. Yes, hello, Mr. Bucket.
Hello, everyone. Yes, I was under the impression that the eco-tourist development application would be done and the other would be just held in abeyance until that was done. I think not being able to see council's legal advice that's confidential to me still denies me procedural fairness, which you can see in my submission. And I think the council's referring to the substance of that advice. I can see from some documents that I've got from the GIPA that I think information given to the lawyers for that advice could well be inaccurate. So I'm asking the panel for the existing use rights DA to be deferred until the eco-tourism one is assessed. I was expecting that the eco-tourism one would have been complete by now, but was held up with working out how much money to pay the council for the application and going to a pre-lodgement panel for about a month. So that's what I would like, is that this one to be deferred until the eco-tourism one is done.
Okay. Can you just answer a question so it's clear? The two structures, the subject of the 2020 DA, are also included in the 2022 DA?
Yes, they are.
Okay, thank you.
And I might add, there's also, council's asked me to add a third structure that wasn't in the other one, the TP, and so we've done that. We think that the Rural Fire Service, well, it's already assessed everything under ecotourism, so that should be fairly straightforward. The only one that they haven't included in their 100B is the TP. So they might just not worry about that, or they might have questions to ask. So that might add in my experience, that might add a month of talking to one another.
Okay, has anyone else got any questions of Mr. Bucket?
Don't
No
have any-
questions? Oh, sorry, Mr. Brunton?
no questions.
Okay. Mr. Story, do you want to speak next? You need your microphone on. Still can't hear you. We can't hear you, Mr. Story. Can anyone hear Mr. Story?
No.
No, we're not getting any sound from you, Mr. Story. Mr. Bucket, can you put your microphone on, please?
Yeah.
Have you got Mr. Story's phone number or something? Send him a text message, tell him that we can't hear him.
Yeah,
He doesn't seem to be picking up on my voice.
I think he thinks we're hearing him.
But we'll all just pause for a minute. We'll keep recording.
Hi.
Yeah, Rod, we can't hear you.
I know, I'm pressing the unmute, unmute. Just
Now
not,
we can hear you. Or are we hearing him
you're hearing me through the
through
the
Mr.
microphone.
Bucket?
mobile phone.
Story, if you just mute your computer again, that may correct it.
Say that again.
If you mute your computer, because I think we can hear you through your computer and through the phone. Through
Okay, okay, thanks.
Chair, would you like to take a short break and then I can contact Mr. Story and rectify?
I think so. We've got plenty of time, yes. So we'll take a 5-minute break. Everyone?
Yeah.
Okay, back in 5 minutes.
Maybe he just needs to turn his volume up.
Turn your micro, yeah. Welcome back, everybody. Now, Mr. Story, I believe you wanted to address the panel about the Barambing
Yes, just
DA
briefly.
196/20. Go right
Yes,
ahead.
can you hear me first of all?
I can hear you.
Oh, good. Thank heavens for that. I changed from a laptop to my iPhone, which seems to be working effectively. Yes, look, without repeating what my client, Mr. Bucket, has said, what we really seek today is for the ecotourism application essentially to be adjourned, and sorry to seek another adjournment, but it seems to me that a lot of the same material is covered in the fresh application, which was invited by council, I might add, and it seems to me that if the present DA is simply rejected out of hand, it then, in order for the client to sort of preserve his rights, he'll have to continue down a sort of an appeal track or another track if he wants to sort of maintain his position. Otherwise, he'd abandon his position, and just, you know, all options would be closed. So what to prevent him having to go down another legal track and so forth, we'd ask that the ecotourism application be considered and finalised, and then all the matters really considered and finalised together, either rejected or approved. Now, obviously, if the ecotourism, we're hoping that will be approved, that will resolve the issue. Alternately, if that is rejected, we'd ask that Mr. Buck would like to instruct council to put his case with respect to the current application, which is scheduled to be not approved, and have the opportunity to make submissions. And to that event, if the panel seeks to do that, which we would not oppose, we'd ask that both parties make submissions, which should be exchanged simultaneously, sometime before the final determination of the panel, so the panel could review both submissions and come to a strong and valid conclusion. My client also is, so far as procedural fairness, he instructs me that he hasn't seen any of the material that council has based, or any of the legal submissions or material that council has based its determination on. And on a basis of procedural fairness, he'd also seek to have access to that material if the panel would so approve. In summary, we just think that the ecotourism application should be fully considered, and this present development application just held in abeyance until that is the ecotourism has been determined, or is determined, or submissions made, or whatever, however the panel wishes to consider it, just to as a matter of simplicity, really. We think it would be a lot easier for everyone, and certainly would save my client an enormous amount of additional work if the ecotourism matter could be finalised. Hopefully, given that the area is actually zoned for ecotourism, hopefully that will see a final positive approval, and then the other matter will simply evaporate it, essentially. So our application today is simply for another adjournment. That's all I have to say. Thank you.
Okay, well, if I may respond, Mr. Story, to some of the things that you've said, it's when you say the ecotourism DA, you mean the 2022 DA?
That's right. Yes.
Yeah,
the one ending in 22. Yes.
I want to make it very clear that what's before the panel today is the 2020 DA.
Yes.
Not
yes.
the 20. The reason that the panel deferred determination of the 2020 DA on the last occasion was to give and for 3 months, give your client a chance to lodge a new DA, which had been mooted in the report by Mr. Johnson back in April.
That's right.
Because for the very reason, the difficulty, as you know, that at the time the 2020 DA was lodged, the type of development, the subject of that DA, was prohibited under the LEP. Whereas now it is not prohibited, and that was seen as a smoother path for your client on any view to lodge a new DA, to just not have to then deal with the difficulty, the prohibited development, and this argument between the parties as to whether existing use rights applied or didn't apply. Now, you'd have to accept it on any view. That's a matter that can be a complicated legal argument, and it's a matter on which minds might differ. So I don't see that's going to assist your client. Firstly, counsel is not going to release its legal advice, as you would appreciate. It's privileged, and they're not going to waive privileged to anyone. So that is not going to your client's not going to obtain that legal advice. But in any event, it is, as I've just said, it's a matter on which minds might differ. And if your client wanted to take it to the Land and Environment Court, that's a matter for him. But
that's right.
It is can be a complicated legal argument, and the council and the panel agreed that the determining officer of the 2020 DA identified that a new DA could be lodged, and your client has taken up that suggestion.
Yeah.
The structures that were the subject of the 2020 DA are the subject of the 2022 DA.
Mhm.
So getting back to what I said at the beginning, the reason that we deferred it, which the panel you would appreciate has to have reasons to defer determining DAs. And the reason, the main reason we determined was to give your client the opportunity to lodge a DA. And there was no denial of procedural fairness, quite the opposite. Getting access to documents is a whole nother issue. And as I've just said, that's a separate it's a separate legislation, it's a separate procedure with counsel. And I understand your client has undertaken that, but the releasing of a legal opinion is not going to be included in that. So there's the perceived benefit that your client is seeking of us deferring the 2020 DA, it seems to have faded away to some extent. And the panel may well disagree with your assessment that it's easier to keep the two DAs running together.
Well, that it may well do. It's more or less a matter of enabling him to continue as he has done so without the additional, depending what he decides to do, of course. But
yes,
if it's rejected, I mean, essentially things come to an end so far as his enterprise is concerned, which then really puts him in a position where he has to make a decision whether he's going to take further action with respect to that, to the DA we've got today, when it may all be all right when the ecotourism one comes through anyway. So it'll then essentially bring his enterprise to a halt, and I think that's what his fundamental concern is.
Where's the suggestion that the enterprise is going to come to a halt? I don't understand council's.
That was my conclusion, and you may correct me if I'm wrong, but that was my conclusion. If it's rejected out of hand at this point, that he essentially won't have approval and therefore couldn't proceed with his enterprise unless he took appellate action or something along those lines, which gave rise to the request or my instructions from him for a request that this matter again be deferred until the DA, the ecotourism DA ending in 2.2 is determined. That's really the
yes. No, I mean the structures that the subject of 2020 are the subject of the new DA.
Yes.
I cannot speak on behalf of council in regard to enforcement action of cause, and I wouldn't expect any of the officers who are present to give any opinion on that as well. But my reading of the papers that are in the public domain and that have been before this panel is that the council has not taken any enforcement action to date to stop. When you say his enterprise has to come to an end,
that was my concern. Yeah.
My understanding of what I have read in the publicly available papers is that there has not been steps taken to close Mr. Bucket down. And as a matter, in my experience of ordinary practice, when an applicant has lodged a development application that seeks approval for it to be properly assessed and seeks approval for structures that may already exist, it's the usual practice that council will allow that to take its course before they would close down an enterprise, which, to use your words.
Yeah, well, that was my concern.
As I say, I'm only speaking
it's his concern. Yeah.
Generally.
Sorry.
Appreciate.
Sorry to interrupt.
Appreciate that might be his concern. And we can't deal with that today, obviously. But the DA, according to Mr. Johnson, as put in his report, is being processed as we speak. I believe it's before the RFS at the moment.
Mm.
And I think some of Mr. Bucket's concerns perhaps don't have, much of a foundation. But anyway,
Okay.
anyone else? Is there anything further you want to say?
I hope
Mr.
you're right. I hope you're right. Please say.
I'm being very careful. what
No,
I
no,
say,
no, no, no.
because
I'm not holding you to anything, of course. No, of course not. But no, that's encouraging. Isn't it?
Now, do any other members of the panel, would they like to say something? We've got two highly experienced town planners and also our community rep who Mr. Rogers, who are obviously on the panel. I have carried on, I have spoken on and on for a bit. Do any of my other panel members like to say anything?
I don't have any questions.
Mr. Hunt? Mr. Rogers?
No questions. Thank you.
Okay, so Mr. Bucket, anything further you'd like? I'm giving you license because we don't have any other DAs to consider. I've exceeded the 3 minutes, which was partly my fault. But
my main concern, I think it's the public interest not to determine the existing use rights DA, because it's just the work and the costs, and it can be expended on appeals and things on that. I don't think the system is pretty long and it's expensive. So even this ecotourism DA, that I can see that could take another month or 6 weeks for the bushfire lot to go through their process. And I just don't see it necessary at all to determine the existing use rights DA.
okay, well, thank you for that.
At this point in time, I think it should be left in abeyance, the ecotourism one done. And then the other two DAs, what they do fall away, it'd be likely I'd just withdraw them. They wouldn't be necessary anymore.
Okay, Mr. Bucket, but you do, I just want to make sure you do understand that the first reason that has been given for refusing the 2020 DA is that it's not, council can't grant, or can the panel grant approval to it if it's a prohibited development. You do understand that's a drop dead consideration, don't you?
Yeah, I'm pretty well across the issues with it, but as you're saying, the existing use rights, different minds will be able to argue over that. For instance, the one of the things is that no occupation certificate, but section 109 M and N of the EP&A Act allows for it not being necessary 12 months after occupations occurred.
Oh, I don't want to go back into all of that detail.
Yeah, no, I'm not wanting to.
Yeah, yeah, I'm sorry, I will cut you short now. I think it's all been explored, and we have considerations in the meeting, obviously, to move things along. The panel you're before today are very familiar with the matter, as you would know, because we've sat on every meeting dealing with your matter. So thank you for that. But I think, and I've allowed your additional written submission today, so I don't think there's anything further that can come.
May I ask just a question, please, just for clarification? Yes. Mr. Bucket, the TP that you made reference to is an additional structure, and you thought that was still for the RFS to take into account. that is a habitable structure in which people would use as like a cabin?
Yeah, well, it falls under temporary building. So council are allowed to continue because under the Caravan and Camping Act, you can have 2 temporary buildings on property without a dwelling and 1 if there is a dwelling. So
All right.
you didn't
I-
really have
I
to
got-
go in, but the council wanted to put it in, and that's fair enough. And the RFS reports and my reports have addressed that anyway. So it
Right,
doesn't have to have-
so individuals would stay in it like a cabin, overnight accommodation, etc.
yeah.
That's all I wanted. Thank you, Chair. Thank you, Mr. Bucket.
Okay, well, if there's nothing, thank you, Mr. Rogers. And thank you for coming, virtually into the virtual meeting room, Mr. Bucket and Mr. Story. If there's nothing further on this item, which is the DA 196/20 for Barrambing, I'm intending to close the meeting because our next item is a matter that's dealt with in a closed session anyway, and we will consider the DA 196/20 as well. Okay, so
Thank you.
can we now please close the public meeting? Okay, everyone, do we? So we're live now, is that correct?
Correct.
Mr. Bucket, are you still in the hearing room? I'm not sure if he's still with us virtually. Tracy? Oh, Mr. Bucket.
Yeah.
Now,
Well-
we've made a decision about your DA 196/20. Can you hear me?
Yeah, I can hear you.
Yeah, the panel's unanimous, and I'll read it out to you. The panel's unanimously resolved that 1, we note the update with respect to the development application DA 2000/22 for ecotourist facilities on the subject site. 2, as the consent authority under the Environmental Planning and Assessment Act for the DA 196/20 for the use of 2 buildings identified as the Enchanted Cave and Treehouse as tourist facilities on Lot 3 in DP 270515, known as 88B Bulgamata Road, Barrambing, is refused for the following reasons. The reasons for refusal: there's one reason, which is the prohibition of development. And I'll read that out to you. The expansion of the tourist facility use has not been found to satisfy the existing use right provisions of the Environmental Planning and Assessment Act, and was, at the time of lodgement of DA 0196/20, prohibited under the Hawkesbury LEP 2012. And there's particulars given A, B, and C. You will, this written document will be available on the council website, I imagine, now or in a very short period of time. And as applicant, you will be sent a copy of that decision. So I've read it out to you. I just haven't read out the particulars A, B, and C. And you'll see that properly on the in full on the council website. Okay,
Okay, thanks.
thank you. You can, thank you, Mr. Bucket, for waiting while we deliberated.
That's okay. Thanks for your
Okay,
efforts.
bye.
Bye.
Now, we go into private session for our advice matter. Does anyone want to break at this, a short break at this point? Not sure.
Happy to press on.
Okay. Thank you.
Still-
Yes,
still-
press on.